Washington is consistently listed as one of the most expensive states to divorce, especially when kids are involved. Why do you think that is?
I don't think that there's enough focus on mediation and alternatives to judicial dispute resolution. One of the things that makes it harder, and this is a double-edged sword. I mean, I understand why the legislature did it, but in domestic violence cases, the court can't order the parties to mediate unless the person who is deemed the victim of domestic violence consents to it. The definition of domestic violence is extremely broad and it's a very low bar. And so you'll have lawyers who will try and drum up an act of domestic violence, no matter how old, so they don't have to mediate. And then what do? You get to charge your client more. And so cases don't get resolved, or mediation happens on the eve of trial instead of earlier in the case. And so you go to trial and the parties haven't even decided who gets the silverware. And so, you know, Washington, I think part of it is our court rules are not set up to encourage alternative dispute resolution. It's there, it's on paper, the window dressing is there, but as far as actually having the rubber hit the road, we haven't implemented it the right way. And I'm not saying that I know the right way to do it. I don't, but I do know that what we're doing is not working too.
Does anybody think that the way our judicial officers run court, or the way the laws are written in the state, that it incentivizes conflict, particularly in a family law matter?
I think there are things in the law that incentivize conflict, and if people can pay for it, they will pay for it if they never got past how much they hate their ex. And you see people who will, at the very first slide or very first disobedience of the parenting plan, will go to court and file a motion for contempt and pay a couple $1,000s and force the other party to pay a couple $1,000s. Mediation isn't always required. And so I do think there are some things in the law, but at the same time, the reason why we did those was in response to decades and decades and decades of not understanding domestic violence and the cycle of violence, that sometimes the other party is continuing that cycle of violence and continuing to abuse them. And so we've got a system that's set up to resolve and help mitigate the damage of domestic violence and end the cycle of violence, because once you're divorced, that should be the end of it, but it isn't. But at the same time, we create other incentives. And so we wind up being this whack-a-mole of, okay, we're doing this, but then we end up creating this problem. And we haven't found the right mix yet. And I haven't studied other states. I don't know if other states have found the magic sauce yet, but I know Washington has it. But I also know that all these laws that we have in place came with good reasons and were in response to very real problems that needed to be addressed. But no, we should never be done tweaking our laws and fixing them and making them better.
Why do judges and commissioners in Spokane and the state of Washington as a whole believe it is acceptable to continually rule that fathers are only allowed to see their children 86 days out of 365-day year, which equals 28.3%, giving Washington a rank of 43rd in the nation for fathers' parental rights?
I've seen that number, and it is concerning, and there's a few things that lead to it. One of them is a change in mindset among judges based upon research. But again, if we're only looking at part of the research, not all the research, we might have bias, and we might need to readdress that and look at other data and reevaluate our beliefs. But another thing is the way our statutes are set up, that if there is domestic violence and a lot of relationships, there is domestic violence, then the court is required to limit decision-making, limit parenting time, unless the court goes through a complicated analysis under 2609-191 subsection N, as in Nancy, and then the court can go and bypass those restrictions. I think a lot of judges don't want to go through 2609-191 and deal with that, because one, it hasn't been briefed to them, and so they don't have enough information. But the other thing too is when we deal with 50-50, that's often a week on, week off schedule. And one of the things that I've heard from research studies is that a week on, week off schedule, those children have worse results than children who are with the same parent consistently throughout the year and then do every other weekend or spend summers with dad. And so I think that's driving some of the decision making. But again, that might not be all the data, all the stuff to look at, but I have heard that week on, week off has become disfavored because of research studies that have shown that children have worse results otherwise. But I don't know what's driving an individual judge or all the individual judges, and maybe that's part of it. Again, this is something where I know I am personally undereducated on what's in the best interest of the child and what is the best decision. I know one of the things that I look at when I'm setting a temporary parenting plan as a pro tem on the court is where do the parents live in proximity to each other and in proximity to the children's school. If the kid has to go from Hayden to Spokane, where their school is, and that drive time between dad's house means that the kid can't be in Boy Scouts, can't be in football, can't be in band. Yeah, that's not in the child's best interest to spend more time with dad if the kid can't be part of their school and extracurriculars. Maybe that is a reason to have restriction on dad if dad's not willing to live closer to the kid's school. But again, cuts both ways. I've also seen moms who live far away and want to restrict kids from being involved in band and other things, and that is not in the child's best interest. And so I do see that situation where the parents split up and they end up living in different towns an hour away from each other, and that brings a big toll on the kids. But there's so many different permutations and other things that go in to each of these cases individually that it's really hard to say that the 28% is 23.8% is just this one thing. I know a lot of it is individual decisions and circumstances, but also it does seem to have a number like that there is something built into the law. And I think part of that is those 191 restrictions I mentioned as part of it.
If I might push back just a little bit, just to have a conversation about this, we have states not far from us that are essentially 50-50 in that same study. Do we have that much more domestic violence? You did mention, I believe you said the domestic violence laws were, did you say vague or broad?
They're broad. They're broad.
Broad, right? So 191 restrictions, possibly not that difficult to get.
But I think that might be part of it. I mean, it is a low bar, and it was intentionally set low because for decades, this state and the country as a whole have turned a blind eye to domestic violence and pretended it didn't exist. For decades, you could, as a husband, beat your wife and it wasn't a crime. Those laws only were overturned this century or this last century in the 1900s, and it was the mid-1900s at that it was decriminalized or actually became a crime to beat your wife. So we are dealing with centuries and centuries of untold abuse and trying to deal with, okay, what's the best way to even the field? And Washington, we've been a leader on this nationally in having laws responding to domestic violence. But as I said in the last one, we haven't found the magic sauce yet. And maybe we've gone too far. Maybe we do need a tweak. But I am hesitant to hold back and pull back. But I'd be curious to know what the domestic violence laws are of those other states that have the 50-50 and how that compares to Washington. I do think that we need to have more time where we look at other states and look at other states' laws, because it's been said that the states are the laboratories of democracy. And so if we're going to change our laws, we need to know what's working and not working in other states.
Studies are coming out showing that women commit domestic violence at the same
Sure.
rate that men do, because when it comes to relationships and domestic violence, it's
Go
usually
combat.
two people
I
beating
don't
each
disagree with
other.
that.
And that's been borne out of my experience as a prosecutor. I've prosecuted a lot of women who committed domestic violence. I had a case right before I left where a woman beat her husband over the head with a big, huge pipe wrench. And thankfully their son was at home to get it on video. But it's there, how many times is it not a kid at home getting that on video? The hard thing is, and what courts do, is we have to figure out who's telling the truth and not. And we get lied to all day long, every day, and we do get hoodwinked. We do get the wool pulled over our eyes, and we do get it wrong. And I wish I had an answer on how to be a better truth detector. And yeah, we do the best that we can, but I'll be the first to admit that we get it wrong, and I get it wrong too. You know, if we wanted to change the law and start with the presumption of 50-50 and then work from there on deviating, we could craft a law that would do that. And there's probably a way to craft a law that would make that work. That's not the law right now, but I'm sure there's a way that there are people out there who could find a way to craft a law that's 50-50 as a presumption, but not that it's always 50-50, but that's just your starting point, and then you work out from there. And so, but that's not what we have. But what is in the best interest of the child, which you asked about, is, yeah, if you asked all 13 judges, you'd get probably 20 different answers. I think you get multiple answers from some judges, probably myself included here. I might give you a couple of answers tonight if I haven't already given you a couple of differing answers on it. And ultimately the best interest of the child, it is in the best interest of a child if they can have two parents and relationships with two parents, even if those parents can't be together anymore. It is in the best interest of every child to have multiple points of view raising them, multiple worldviews raising them. One of the things that I've seen that's been really sad is I've had parents come to my court where you've got a Caucasian mom and a Puerto Rican dad, or a dad who's African-American from Baltimore. And you've got a mom who wants to cut off all contact and have this mixed race child not have any contact with their Puerto Rican heritage or their Black heritage, and only learn about their white heritage living here in Spokane. No one would say that it's in that kid's best interest to have no relationship to their dad, to have no relationship to that extended family, because having a relationship to both parents isn't just a relationship to two people, it's two extended families with multiple generations of knowledge. I think it's always in the kid's best interest if they have more people raising them, but ultimately it's can it be done safely? And that's the overriding concern. Can it be done safely without traumatizing the kid mentally or physically? So I do think there are ways to do it, and I think these are things we need to be cognizant of. But definitely, there are big concerns with the way things are done now that I don't think are necessarily right, but I also don't have enough hubris to say that I know how to do it better. As far as judges following the law, I think that's really important. Every lawyer, when they become a lawyer, they take an oath of attorney, and part of that oath of attorney is also the same as the oath of the judge, is to uphold the laws of the United States and the Constitution of the United States and of the state of Washington and the laws of the state of Washington. But there are judges who sometimes ignore the law and they want to make a stand. And you see it where judges say, well, I'm going to do what I'm going to do, and if you don't like it, appeal me. And they don't appreciate the expense that comes with an appeal, and that an appeal is an imperfect remedy and often comes too late. It's too little too late. And you need judges who understand that even though they're the last stop, sometimes they're first stop, often they're the only stop, and there is no effective remedy. One of the things that's in the back of my mind, Judge Fennessy last week got reversed by the Court of Appeals for failing to follow black letter law in a divorce case. He found that there was domestic violence, and he failed to apply that 191 statute I just told you about. At the start of the year, he got reversed in another divorce case for not following a prenuptial agreement. He found that the prenuptial agreement was valid, which meant it was binding, and then he just turned around and ignored the provisions of that binding contract and said, I'm not going to enforce it. I'm putting words in his mouth. He didn't actually say, I'm not going to enforce it. That was the effect. And so you wonder if a judge is willing to just ignore black letter law, willing to ignore a binding contract that he already found on the record to be binding. You wonder what's going on.
With a military person, there's this, especially combat veterans, it's very easy to say they're crazy or they have PTSD and stuff like that.
I think the thing that judges need to keep in perspective is, we're talking about family law cases. A lot of times, these two people, they're getting divorced for a reason. They can't make it work. That's abundantly clear, especially if it's a contentious divorce. But just because these two people can't be in the room together doesn't necessarily mean that either parent is a risk to that child or is going to abuse that child physically or mentally. Sometimes there are parents who do have PTSD or do have problems with their former spouse and can't be in the same room as them, and it always devolves when they get in the same room, but who can with that child, they're the best parent in the world. And so it's incumbent on judges to do that record making, listen to all the evidence, review it critically, have a good GAL, which is another issue altogether, but have a GAL who's going to investigate all of that, because oftentimes there are two parents who are a physical threat to each other, but neither one would ever hurt a hair on that child's head, at least not intentionally. Dale's right, cases take way too long to get decided, and there are aspirational guidelines on when they're supposed to be done, criminal and civil. And it's too late. We've all heard justice delayed, justice denied, and it's true. But fixing that, that's not just an issue in Spokane or Washington, that's nationwide. That is a cultural problem within the law. And no single judge can deal with that. You've got a legal system that's set up for the civil and high volume litigation, and in the family law, high volume litigation, which means you just churn through cases. But that means that you're churning through so many cases, all of your other cases are on the back burner. Criminal is that way by default. and you're constantly putting out fires. And we would need to radically restructure our legal system and the culture of lawyers to get rid of all these continuances. It's a problem. It's a huge problem. But if you have one judge who is gonna say, no, we're not gonna do continuances, that judge is gonna be next up on those hundreds of notices of disqualification. So it will be out. You would need coordination from the bench and bar and agreement and buy-in, but that is a problem that no jurisdiction in America has solved.
Pro se litigants, do you feel like the resources available to pro se litigants are good enough?
I don't even think we have remotely anywhere close to the resources we need for people to represent themselves. When I preside over protection order dockets, frequently I have people who come before me and say, I've got the evidence on my phone. Can't you just take a look at my phone? Can't I pass it up to you? And I have to say, no, I can't. You have to give it to the other side. You have to serve them. You have to figure out how to serve them. I could take your cell phone and log it into evidence, but then it becomes the courts and you're not getting your phone back. Can you live with that? And so what we've done in Spokane County is to tell people how to get their electronic evidence in, the evidence on their phone, is we give them a sheet of paper with dense instructions that so many of these people who come to the court, they're not high school graduates, they don't have a GED, some of them dropped out of school in junior high, but they still need to access the court. They might have dyslexia and can't even read it. A lot of these people, they don't have disabilities as defined by the Americans with Disabilities Act, so they're not entitled to an accommodation under the law. And these people, yeah, we can lead a horse to water, but if you can't read the sheet of paper that we give them, how are they going to get it in? We need people who are going to meet people where they're at, understand their limitations, and work with them to overcome their limitations. That is what courts need to be doing to help people who are self-represented. But again, that comes back to where's the money? And I don't know.